morning, madam. My name is Whitney, and they are my group member, Ling Ying Ying, Ling Qianyuan, Teo Qifang, and Ng Jing Yi. Today, we will be presenting our video presentation for Contract Law 2 regarding the legal dispute between MLA Development Sendirian Berhad and Aman Build Sendirian Berhad. The purpose of this presentation is to analyze whether the construction contract between the parties were discharged by breach of frustrations and to evaluate the remedy available to both parties under the principle of Malaysia contract law. In this presentation, we will discuss the relevant provision under the Contract Act 1950 together with important cases law. We will also apply the legal principle to the facts from both parties' perspective before reaching our conclusions. Now, I will begin with the introduction, contract formation, and the key contractual terms between the parties. The first issue is whether a valid construction contract was formed between MLA and Aman and what the key contractual terms are. Under the Contract Act 1950, a valid contract generally requires offer, acceptance, consideration, and intention to create legal relations. Under Section 2, Subsection A, an offer is made when one party signifies their willingness to do something with a view to obtaining the other party's assent. Under Section 2, Subsection B, acceptance occurs when the person to whom the proposal is made signifies assent to it, while under Section 2, Subsection D, consideration refers to something of value given in return for the promise. In a commercial agreement, the law usually presumes that the party intended to create legal relations. Applying this to the fact, MLA and Aman clearly entered into the valid lighted construction contract in January 2024. MLA offered to pay 12 million for the construction of a 3-story commercial complex in Sungai Penjara. Aman accepted this obligation by agreeing to carry out and complete the construction works. The consideration is also clear. Aman consideration work is promised to construct and complete the commercial complex, while MLA consideration work is promised to pay the contract sum of 12 million. There were also intention to create legal relation because this was not a social or family arrangement. It was a commercial construction contract between two companies. The agreement was also made in writing, which strongly support the existence of a legally binding contract. Therefore, based on the fact, all the essential elements of a valid contract were certified. Next, the contract contains several important aspects. The first key term concerns payment. Payment was to be made through 4-stage payment upon certification by MLA architects. By August 2024, Aman had completed about 75% of the works, and MLA had already paid 9 million for the first 3 certified stages. This initial compliance demonstrates that both parties originally performed in accordance with the agreed mechanisms. The second term is that time was expressly stated to be of the essence. Aman was originally required to complete the project by 31 December 2024, but the deadline was later extended to 31 March 2025. MLA also promised an additional 500,000 ringgit conditional upon Aman maintaining reasonable progress. However, Aman progress slowed significantly and eventually stopped between November 2024 and January 2025. Therefore, MLA may argue that Aman breached the strict time obligation and failed to proceed diligently. The third key term is the termination clause. MLA was entitled to terminate the contract if Aman delayed the project or failed to proceed diligently. On 15 January 2025, MLA issued a formal notice requiring Aman to resume work within 14 days. Aman later admitted that it was financially unable to continue the work. Therefore, MLA may rely on the termination clause to justify its termination of 10 February 2025. The fourth key term is the force majeure clause, which excuses non-performance caused by events beyond the party control, including acts of God and government interventions. Here, the severe frauding may amount to an act of God, while the 2 years prohibition order may amount to government interventions. Aman may rely on this clause to excuse of non-performance. However, MLA may argue that Aman was already in breach before the frauding occurred. There was also a September 2024 arrangement where MLA agreed to extend the completion date and promised an additional 500,000 ringgit provided Aman maintained reasonable progress. Since Aman later slowed and stopped work entirely, MLA may argue that this condition was not fulfilled. In conclusion, a valid and enforceable construction contract was formed between MLA Development Sendirian Berhad and Aman Build Sendirian Berhad. The written agreement clearly set out both party obligations. Aman had to complete the construction works, while MLA had to make payment according to the agreed stage payment arrangement. The key contractual terms include the stage payment clause, the term that the time was of the essence, the termination clause, and the force majeure clause. These terms are important because they determine the party right and liability when the project later becomes delayed and incomplete. And now I will pass it to Ying Ying.
Thank you, Winnie. Now I will discuss issue 2, which is whether Aman Build Sendirian Berhad breached the contract by failing to carry out the construction work diligently and complete the project on time, allowing Emerald Development the Sendirian Berhad the right to terminate the contract under Section 40 of the Contract Act 1950. Under Section 40 of the Contract Act 1950, When one party refuses to perform the contract or make itself unable to perform its obligation entirely, the other party may terminate the contract unless that party has accepted or continued the contract despite the breach. The relevant case for this issue is Rasia Munusami and Lim Tan and San Srendan Berhad. In this case, the respondent orally agreed to sell and transfer a double-story terrace house to the appellant and also undertook to construct the house. Later, a dispute arose concerning the balance of the purchase price that was payable by the appellant. The appellant refused to pay the outstanding amount, and the respondent claimed that this refusal amounted to repudiation of the agreement. As a result, the respondent treated the contract as terminated. The issue for this case is whether the purchaser conduct amounted to a repudiatory breach, allowing the vendor to terminate the contract under Section 40 of the Contract Act 1950. The Federal Court, however, held that not every refusal or breach automatically amount to repudiation under Section 40. The court stated that there must be a clear intention to abandon the contract entirely or an absolute refusal to perform the contractor obligation. In this case, the appellant conduct did not show such clear repudiation, and therefore the respondent was not entitled to terminate the contract. The principle established in this case is that Section 40 only applies when a party conduct clearly shows refusal or inability to perform the contract in its entirety. The other case to consider is Chin Yik Development Srendan Berhad and Setapa Heights Development Srendan Berhad 1997. The fact of this case are the parties entered into a construction and development contract. The contractor was required to complete the works within the agreed timeline and to proceed diligently. A dispute arises when the contractor allegedly failed to carry out the work properly and on schedule. The plaintiff treated this conduct as a repudiatory breach and sought to terminate the contract under Section 40. However, the defendant denied repudiation, argued that the contract was still valid. The key issue was whether the defendant conduct amounted to a repudiatory breach justifying termination under Section 40. The court held that not every delay or breach amount to repudiation. There must be clear evidence of an intention not to perform or an inability to perform the contract in its entirety. Termination is justified only if the conduct shows a fundamental refusal to continue performance. Mere delay or imperfect performance alone are insufficient. The principle for this case is a breach of fundamental terms gives the innocent party the right to terminate the contract and be discharged from further contractor obligation. In contrast, a breach of a minor term does not justify termination. The innocent party may only claim damages for the loss suffered, and if they wrongfully terminate the contract, they themselves may become liable for breach of contract. The application of this issue is, from a Merlin perspective, first, the contract expressly provides that time is of the essence and that a Merlin may terminate if there is delay or failure to proceed diligently. By November 2024 to January 2025, Amman works has lost significantly and eventually ceased entirely, leaving approximately 25% of the project incomplete despite the extended deadline. This indicates a serious failure to progress within a construction contract where timely completion is fundamental. This situation is similar to Chin Yik Development Srendan Berhad and Setapak Heights Development Srendan Berhad, where the court held that although mere delay is insufficient, termination is justified where there is clear evidence of inability or refusal to perform the contract in its entirety. Here, Ayman not only delayed but ultimately stopped work completely, which goes beyond mere minor delay and indicate an inability to continue performance. Further, Ayman's statement that it was financially unable to continue the project strengthened a moral position. In Rasia Munusami and Lim Tan and San Srendan Berhad, the court held that Section 40 applies only where there is a clear refusal or incapacity to perform the contract as a whole. Unlike a mere payment dispute in Russia, Ayman's admission of financial incapacity coupled with cessation of work shows a practical inability to complete the contract, supporting termination under Section 40. Additionally, Ayman had already received 9 million out of 12 million, yet failed to complete the remaining works, reinforcing the interference of serious non-performance. Therefore, a moral can argue that Ayman has repudiated the contract by conduct, justifying termination on 10 February 2025. In conclusion, Ayman conduct amount to a repudiatory breach under Section 40 Contract Act 1950, as Ayman has refused or disabled itself from performing the contract in its entirety. On the other hand, from Ayman's perspective, its conduct does not amount to repudiation under Section 40, and instead the contract was ultimately discharged by frustration due to supervening event. Aman may rely on Russia Munusami, where the court emphasized that not every refusal or failure to perform amount to repudiation, and there must be a clear intention to abandon the contract or absolute refusal to perform. Aman can argue that its delay and evasion stoppage were not intentional abandonment but were caused by external financial pressure and unforeseen circumstances, rather than a deliberate refusal to perform. Aman will also argue that it had been actively negotiating with Emerald, including requesting additional payment and extension of time, and that Emerald had in fact agreed in principle to extend time and pay 500,000. This indicate continued recognition of the contract rather than repudiation. Most importantly, Aman contended that the contract was ultimately frustrated by severe flooding, destroying substantial part of the work, and a government order prohibiting further construction for 2 years. These events are supervening, unforeseen, and beyond control, making performance legally and physically impossible. Under Malaysian contract principle, this would discharge the contract by frustration rather than breach, shifting the risk away from Aman. Therefore, Aman argued that its failure to complete the contract project is not repudiatory conduct under Section 40, but rather a consequence of frustration occurring after significant completion of work, entitling it to be relieved from further obligation and possibly claim under restitution principle for work done. Legal advice for Ermelan is Ermelan was entitled to terminate the contract under Section 40 of the Contract Act 1950 due to Aman's inability to continue the project. Ermelan may claim damages for the cost of a replacement contractor, delay losses, and loss of anticipated rental income. However, the building and government prohibition order may limit Aman's liability for losses arising after those events. Ermelan should retain all notices, payment record, correspondence, and progress report to support its claim. In conclusion, Ahmad built Sajan Berhad committed a fundamental repudiatory breach by failing to proceed diligently and becoming financially incapable of completing the project despite the extended deadline. That's all for my part. I will pass to Qifang.
Thank you, Ying. Moving forward, I will now be discussing the third issue, which is whether the September 2024 agreement, where Emerald agreed to extend the completion date and pay an additional 500,000, constitutes a valid and enforceable variation of original contract, particularly regarding whether valid consideration existed to support the variation. The first relevant provision is Section 63 of the Contracts Act, which provides that parties may agree to alter an existing contract, and the original contract need not be performed once varied. However, courts often examine whether there is sufficient consideration or some other basis, such as practical benefit, to support the variation. Under Section 2D, consideration is an act, abstinence, or promise made at the desire of the promiser. The principle of what constitutes a valid consideration in a variation was established in the case of Stilk and Myrick. In that case, a ship was sailing from London to the Baltic Sea and back, and the sailors were promised £5 a month. Two sailors then deserted and abandoned the ship. The captain couldn't find replacements and promised the remaining crew extra wages if they worked harder to bring the ship back short-handed. The crew did so, but the captain refused to pay. The issue was whether the promise of extra payment was enforceable when the sailors were already contractually bound to complete the voyage. In the end, the court held that the captain did not have to pay the bonus, as the sailors were merely fulfilling the existing contractual duty, and a promise to perform an existing contractual duty is not good consideration for a variation. However, this position was refined in the case of Williams and Roffey Bros and Nicole Contractors Limited, where the main contractors, Roffey Bros, hired a subcontractor, Williams, to do carpentry work on 27 flats. Williams then could not finish on time, so Roffey Bros promised him a bonus to complete the work on schedule. Eventually, Williams continued working, but Roffey Bros stopped paying, and then Williams sued the firm for the unpaid money. The issue was whether the promise of extra payment was enforceable even though Williams was already contractually bound to complete the work. It was then held by court that the promise was enforceable because Roffey Bros obtained a practical benefit from Williams, continuing the work and avoiding financial penalties. The principle established is that where a party receives a practical benefit from the other party's continued performance, that practical benefit may constitute sufficient consideration, even if the other party is merely fulfilling a pre-existing duty. Now for the application part. From Aman's perspective, Aman can argue that the September 2024 agreement is a valid and binding variation under Section 63, as Emerald agreed in writing to extend the deadline to 31st March 2025 and pay a 500,000 ringgit, satisfying the requirements of offer, acceptance, and consideration. Aman would contend that it provided fresh consideration by continuing construction works in reliance on Emerald's promise of the additional 500,000 and extended deadline. Furthermore, Emerald obtained a clear practical benefit from this arrangement. At 75% completion, terminating Aman and appointing a replacement contractor would have caused significant delays, additional costs, and disruption to the entire project. Following Williams and Roffey Bros, this practical benefit is sufficient consideration to support the variation. However, from Emerald's perspective, they could argue that while the variation may be valid, it was expressly conditional, as the additional 500,000 was only payable if Aman maintained reasonable progress. Since Aman's work slowed significantly from November 2024 and eventually ceased entirely, the condition precedent was never fulfilled, and Emerald's obligation to pay the additional sum never arose. Emerald would further contend that Aman's continued performance was nothing more than its pre-existing contractual duty, and under Stilk and Myrick, this can amount to fresh consideration to support the variation. To conclude, the September 2024 agreement is likely to constitute a valid variation under Section 63 because Emerald obtained a practical benefit from Aman's continued performance consistent with Williams and Roffey Bros. Nevertheless, the additional 500,000 was expressly conditional upon Aman maintaining reasonable progress. Since Aman subsequently ceased work, Emerald has a strong argument that the condition was not satisfied and therefore the additional payment is not recoverable. As for advice to the parties, Emerald should always ensure that any variation to a construction contract is documented through a formal supplementary agreement, clearly setting out the conditions, revised timelines, and payment terms to avoid ambiguity. As for Aman, the company should have ensured that the full amount requested was agreed upon before continuing works, and should have raised any financial difficulties earlier rather than allowing the work to cease entirely. Both parties would also benefit from including a clear dispute resolution clause in future contracts to manage such disagreements more efficiently. That's all for my part. I will now pass the floor to Qianyan.
The fourth issue is whether the contract between Emirates Development Sdn Bhd and Aman Build Sdn Bhd has been discharged by frustration due to supervening events, namely the severe flooding in February 2025 and the local authorities' order prohibiting constructions for 2 years. Section 57 Clause 2 of the Contracts Act 1950 provides that a contract is discharged when, after it has been formed, and unforeseen events beyond the promisor control makes performance impossible or renders the agreed act unlawful. At that point, the contract becomes void. Next, in Biggs Industrial Gas Sdn Bhd versus Pon Vijaya Properties Sdn Bhd, the vendor failed to obtain the required land transfer consent due to errors in its applications and subsequently claimed frustrations. The Court of Appeal held that the contract was not frustrated because the impossibility resulted from the vendor's own actions. The principle established is that self-induced frustrations cannot discharge a contract under Section 57 Clause 2. The Court of Appeal held that there was no frustrations as the failure resulted from the vendor's own mistakes and refusal to act. Accordingly, it was self-induced frustrations. The SPA remained valid and the vendor was liable for a breach while the purchaser was entitled to damages. In Technokota Sdn Bhd versus Setapak Heights Development Sdn Bhd, the parties entered into a sell and purchase agreement for land, but the plaintiff bank loan was withdrawn following the 1997 to 1998 financial crisis, preventing completions of payment. The issue was whether the contract was frustrated or governed by Clause 5 of the SPA. The court held that Section 57 Clause 2 applies only where performance becomes legally or physically impossible and express contractual provisions on supervening events prevail over frustrations. The court found no statutory frustrations as the financial crisis and withdrawal of financing were beyond both parties' control and the plaintiff was entitled to a refund. From Aman Build Sdn Bhd's perspective, it may argue that the contract has been frustrated. The severe flooding constitutes an act of God that caused significant damage to the partially complete works. Furthermore, the local authorities' order prohibiting constructions for 2 years may render performance temporarily impossible and substantially delay completions. Aman may therefore contend that these supervening events have fundamentally changed the nature of the contract and made performance impossible within the agreed timeframe. From Emirates Development Sdn Bhd perspective, frustrations does not apply as the failure to perform was not solely caused by supervening events. Emirates would argue that Aman had already delayed constructions between November 2024 and January 2025. Furthermore, Aman's admissions of financial inability suggest that non-performance was partly due to its own circumstances. In line with the principle in Big Industrial Gas Sdn Bhd versus Pon Vijaya Properties Sdn Bhd, frustrations cannot be relied upon where the ability to perform is self-induced. Additionally, the existence of external difficulties does not automatically discharge the contract under Section 57 Clause 2. In conclusion, the contract between Emirates Development Sdn Bhd and Aman Build Sdn Bhd is unlikely to be discharged by frustrations under Section 57 Clause 2 of the CA. Emirates Development Sdn Bhd is advised to terminate the relevant contract strictly in line with its contractual provisions and claim compensations for losses arising from the other party contractual breach. Aman's Build Sdn Bhd is recommended to resolve the dispute amicably by carrying out direct negotiations or participating in formal mediation proceedings. For both contracting parties, it is prudent to explore an economically viable commercial settlement to prevent lengthy, costly litigations from dragging on. That's all from my part. Now I'll pass the floor to Jingyi.
After discuss the issue of violation, breach, and frustrations, I will now move on to the remedy available to the party. Next, first, IMA may argue that it is entitled to the additional 500,000 ringgit promised by the Emirates under the variations agreement made in September 2024. The key authority is Williams and Roffrey Bros, where the court recognized that a practical benefits may constitute valid considerations for a contractual violations. In this case, Emirates agreed to grant both an extension of time and additional 500,000 ringgit because it wanted Aiman to continue with the project. By doing so, Emirates obtains a practical commercial benefits. It reduced the risk that the project would be abandoned and increased the likelihood that constructions would be complete. However, Aiman faced a significant difficulty. The violation was granted on the basis that Aiman would continue and complete the works. In reality, Aiman failed to do so. Construction eventually stopped, and Aiman admitted that it no longer has sufficient financial resources to continue to perform the contract. As a result, although the variations may initially has been supported by valid considerations, Aiman cannot rely on it because the promised performance was never complete. Therefore, Aiman is unlikely to succeed in claiming the additional 500,000 ringgit. I will now turn to Emirates remedies. The first question is whether Aiman conduct amount to a repudiatory breach under Section 40 of the Contract Act. The relevant authority is Rasha Monusami and Lim Tan and Sons Sendram Berhad. The court explained that Section 40 applied where a party either demonstrated an intentions not to perform the contract or placed itself in a position where it can no longer perform its obligations substantially as agreed. This principle provides the basic for determining whether Emirates was entitled to terminate the contract. Applying Section 40 to the fact, Aiman conduct appears serious enough to amount to a repudiatory breach. The evidence shows that construction progressed slowed considerably from November 2024 before work eventually stopped altogether. At the stage, around 25% of project remained unfinished. More importantly, Aiman openly admitted that it was facing several financial difficulty and could not continue the construction work. This is significant because it demonstrates that not merely a delay, but an actual inability to perform the demanding contractual obligations. Emirates then issued a 14-day notice requiring Aiman to resume work. Despite being given that opportunity, Aiman remained unable to continue the contract. In these circumstances, a court is likely to conclude that Aiman has effectively disabled itself from performing the contract and had renounced its obligations. Accordingly, Aiman contract fall within Section 40, and Emirates was entitled to treat the contract as repudiated, terminate the agreement, and pursue remedy for breach. Next. Once the contract has been lawfully terminated, Emirates may claim damage under Sections 74 and 76 of the Contract Act. Section 74 allows compensations for loss that naturally arise from a breach, while Section 76 permits compensations where a contract has been lawfully rescinded. Applying these provisions, Emirates may recover several categories of loss. First, Emirates may claim the additional cost of appointing a replacement contractor to complete the remaining 25% of the project. This cost arises directly from Aiman's failure to perform the contract. Second, Emirates may recover loss resulting for the delay. Although Emirates has already granted an extension until 31st March of 2025, Aiman was still unable to complete the project within the revised period. Third, Emirates may seek compensations for loss of anticipated rental income. The commercial complex was extended to generate revenue upon completion, and because the project remained unfinished, Emirates lost the opportunity to list the permits and earn income as planned. In addition, Emirates may rely on the Specific Relief Act 1950. Under Section 34, a contract may be rescinded where the other party has committed a repudiatory breach. Since Aiman stopped work and admitted that it could not continue, Emirates was justified in rescinding the contract. Following restriction, Section 37 empowered the court to award reasonable compensations where justice required. Therefore, Emirates may seek compensations for the loss flowing from the restrictions, including replacement contractor costs, delay loss, and loss of anticipated rental income. Although Aiman may be liable for breach, it may still attempt to recover payment through the doctrines of quantum merit. The phrase of quantum merit means as much as he deserves. It allows a party to recover reasonable remunerations for work that has been performed and accepted by another party. The leading Malaysia authority is McDonald Malaysia Sdn Bhd and Hock Dear Realty Sdn Bhd. In that case, the court recognized that compensations could still be awarded where variable service has been rendered and the benefits of those service has been retained by the other party. The principle is simple. Where one party has conferred a variable benefits that have been accepted and retained, reasonable compensations may be awarded. Applying that principle to Aman case, Aman complete approximately 75% of the construction work before the work ceased. Emirate therefore received a substantial benefit from the work already carried out. However, other merit does not permit double recovery. The facts show that Emirate has already paid 9 million for the first 3 certified stages of construction. Therefore, Aman must prove that it complete additional work beyond the value already paid for. Only if it can demonstrate that Emirate retains an unpaid benefit will further compensations be available. Accordingly, while a quantum merit claim is theoretically possible, its success depends on whether Aman can establish the existence and value of any unpaid work. I will now consider the alternative argument that the contract was discharged by frustration. The relevant provision is Section 57, Clause 2 of the Contract Act, which states that a contract becomes void when an event occurring after formations make performance impossible or transforms the obligations into something radically different from what was originally agreed. Once frustration occurs, Section 66 dealt with the consequence by requiring benefit received under the contract to be restored or compensated for. The leading authority is Public Finance Berhad and L1T4. The court held that when a supervening event rendered contractual performance impossible, the contract becomes void and restitutionary obligations arise under Section 66. Importantly, frustration is not concerned with fault. Its purpose is to prevent one party from being unjustly enriched at the expense of the others. Applying this principle, Aman may argue that two supervening events fundamentally changed the nature of the contract. First was several flooding which damaged part of the partially complete structure. Next was a government order prohibiting construction activity for a period of 2 years. Both events occurred without the fault of either party and were not reasonably contemplated when the contract was originally formed. The 2-year prohibition is particularly significant because it would substantially delay completions and undermine the commercial purpose of the project. While a short delay would not normally frustrate a contract, a delay of his magnitude may make performance radically different from what the party originally intended. For that reason, Amas has a credible argument that the combined effect of the flooding and government restriction frustrated the contract under Section 57, subsection 2. However, Emirate is likely to argue that true cause of non-performance was Ayman's financial inability to continue construction, which existed before this event occurred. If the court accepts that argument, the doctrine of frustration will not apply because a party cannot rely on self-induced frustration. Therefore, the success of Ayman's argument depends on whether the court views the supervening event or Ayman's financial difficulty as the real cause of the failure to perform. If the court concludes that the contract was frustrated, the consequences are very different from those arising from breach. Under Section 66, any benefit received under the contract must be restored or compensated for. This means that Ayman may seek reasonable compensations for the work that already complete and retained by Emirate, while Emirate may seek restitutions for benefit previously transferred under the contract. Most importantly, frustrations does not include fault. As a result, damage for breach under Sections 74 and 76 are not available. Emirates would therefore be unable to recover replacement contractual costs, delay loss, or loss of anticipated rental income as breach damage. Instead, both parties would be limited to restitutionary remedies aimed at preventing unjust enrichment. So, in short, if frustrations is established, the contract is automatically discharged and the party rights are governed by Section 66 rather than the ordinary law of constructural damage. Next. To conclude, the stronger legal positions appear on the part of Emirate. Although the flooding and government prohibitions order significantly affected the project, Emirates has already stopped constructions and admitted that it lacked of financial resources which necessary to continue the performance. For that reason, the contract is more likely to have been discharged because of Ayman's repeatedly breach rather than frustration. In addition, Ayman is unlikely to proceed in claiming the additional 500,000 ringgit under the variations agreement because it failed to complete the work for which payments was promised.
Accordingly, Emirates was entitled to terminate the contract under Section 40 of the Contract Act and may recover damages arising from Aman's breach. By contrast, Ayman's recovery is likely to be limited to a quantum merits claim for any unpaid work that provided a miserable benefit to Emirates. Therefore, on the balance of probability, Emirates is likely to succeed in this claim. That's all from us. Thank you.